So for those of you who don't know me, and I didn't get a chance to speak to all of you before we kicked off, my name is Belinda Cheng. I work at EY, I'm a director there, and I work as their Asia Pac Tax Innovation Leader. I also spend a lot of time in the startup scene, so I look after the EY Foundries Singapore and Sydney, which is a startup incubator for early stage startups in the tax and accounting space. Perhaps not sexy industries, but we think they're pretty sexy. But I've got the great pleasure here today, and thank you all for coming, of having a good chat with James. So James Wan is the General Counsel and also the Company Secretary of Harrison.Ai. And you know, for those of you who haven't heard about the amazing story of Harrison.Ai, it's pretty tremendous. $29 million capital raise, you know, literally sort of a success, incredible success story in the making, and you know, has had some incredible pedigreed, high-profile investors put, you know, tip money into it. So I think we're hopefully going to see a unicorn in the making, James. So. This is, like Lauren said, it's a very intimate event, so, you know, I'd really love to, you know, keep this very conversational and very interactive. So if there's a question that you're dying to ask, please interrupt us. But before I hand over to James and get him to introduce himself to you, just a bit of a quick straw poll. How many of you are actually in the process of, you know, thinking about going to raise, or is it something that you're looking at doing in the next 6 to 12 months? Yeah, okay, there's a few of you there. And like, where would you rate yourself in terms of your knowledge of understanding the process? Sort of fairly minimal, mid-range, okay, cool, okay. So we'll make sure we start from that basis. I hope that works for everyone else. And you know, as I said, let's just make this really interactive and really conversational. So James, thanks so much for joining. It's lovely to have you here. It'd be great maybe just to start with, just give us a little bit of a story about yourself and how you landed at Harrison.Ai.
Oh, you know, it's working. Yeah. Yep. I'd like to say, you know, thanks to Lauren and HHQ for inviting me over here, and also to Belinda for the wonderful intro. I'll give a little bit more intro about myself. So my background is as a lawyer. I graduated from UTS a long time ago, so I have a Bachelor of Computer Science as well as a Bachelor of Law. I've been practicing as a lawyer now for about 17 years, and I've worked in Asia for about 9 years, both in Singapore and in Hong Kong. And so I was working in a firm as a patent attorney, so my area of practice was in IP law, and the founders of Harrison.Ai at the time, they approached me because they knew that I had done work for other AI clients in the past. And so they knew that they needed expertise in IP. They didn't have a lawyer on deck as well, so that just came as a 2-for-1 kind of deal. And they told me a little bit about what they were doing, and they had some success in their first product, which was an embryo selection AI. And they had sold that to Virtus Health, or it was done in collaboration with Virtus Health. And that got me interested because I hadn't actually met a client that actually had commercialized an AI in a sort of a medical field. And so I said that was great. But I didn't want to go into a company that was only focused on one area of healthcare, because I had been in that situation before when I worked at ResMed. And so they deal with sleep apnea, but that was their primary sort of disease that they did. So it wasn't, I needed something a little bit more interesting, and then they told me that they were looking at other areas as well, and that they were actually quite mature in the discussion with IMED in the radiology field. And so the co-founder explained to me what the plan or the business model of, and then that's what got me interested, and I said, you know, yes, you know, I'd like to join them on their journey. And that was about 9 months ago in June last year. And I have a colleague here, Robin, he's from Harrison.Ai as well, and he started just after me, and there was just like 10 of us in the office, so I think I was the 10th one to join. And yeah, so when I started, I mean, one of the first things that I was tasked to do was to negotiate the joint venture with IMED, so all the legal agreements with IMED. And so IMED is a $1 billion company, and they're world's largest radiology network, primarily in Australia. So that was a commercial kind of deal. And then as we were about to conclude that, and that took a few months, it was straight onto the capital raise. So the company, the value, because of the fact that we had a joint venture agreement with IMED, pushed the value of Harrison up because the potential for us to commercialise an AI product with IMED was much more valuable than if we didn't have a commercial partner. So then we get to the capital raise part, which I think Belinda's going to have a few questions for me as well.
Yeah, no, definitely. And this is where I think we can try and level set. So we've got a slide here to my right, which really sort of takes us through the process of how it all happened. So maybe James, I could, I guess if I could just get you to share with the audience, what was the journey? And I think maybe if we can use this slide as a bit of a guide to help you through that, and hopefully as well that helps you as well as the audience.
Right. So the typical journey is that you need to raise money. You raise money from investors, and depending on where you are in your journey as a startup, you'll either start with a seed round or an angel round. So an angel round is where it's friends, family, and fools basically. That's the initial stuff, where it's really just a promise, and you really don't really have any runs on the board. It's just like, they're just backing you because they like you as a blood relative, for example. And then at a seed round, you might go to like angel investors, people who invest in startups, and they sort of do it semi-professionally. And then, or you might go to institutional investors, which is what happened in this case. And so by the time that when I joined Harrison.Ai, the two co-founders had already been talking to a lot of investors, as I understand it, and they'd already, it got quite mature. Like there was already a kind of term sheet that was already prepared. But this was before the deal that we had with IMED, and so when that concluded, we revisited the capital raising part. So because they had those relationships with those other investors, it was much easier to go back to them and say, hey, there's been an update to our business, and pitch again to them with a new sort of pitch deck that they had. And then the investors, what will happen is when the investors are interested, you will prepare a term sheet. The term sheet basically sets out all the commercial terms. So what is the value that you think your company is? And that's an area for negotiation, because you might say my company's worth 10 million, and the investor said there's no way it's 10 million, it's 5. And this matters because the money that you get dilutes you down, so that's the percentage ownership that the investor will have. So it's pretty important to get the valuation right, and you need to try and justify that, or at least persuade the investor why you believe in your numbers with whatever external evidence that you have, or with just pure conviction and just repeating it that I'm worth $10 million or something like that. So that's the salesman aspect of that term sheet. Then there's other terms. So after you've established that, you want to know how much you want to raise, and the question will be, why do you need to raise that much? What are you going to use it for? And then after that, you'll go into what rights do the investors have, because the investors will have what you call preference shares, and everyone else, including the founders, will have ordinary shares. So preference shares have additional rights attached to them. So the additional rights typically are anti-dilution rights, so they always have an ability to stop themselves from being diluted down from further investments. They also have like voting rights in terms of so there'll be some special decisions or resolutions of the company that are reserved, or they require at least the majority of the investors to agree on before they can be passed. So things are like changing the fundamental nature of the business, or taking on a loan above a certain amount. So the investors will have, and especially if they're a repeat, like if they're an institutional investor, they'll know exactly what they want to come in with. But these are all negotiable terms. So if you're the founder, you shouldn't and this is probably the lesson I want to stress, is that it's great to be invested in. I think that's a really big milestone, but that's the journey's not over yet. You still have to and you should negotiate the terms that are attached to that money that they're going to invest, because it's a long-term relationship between the founders and actually the whole company and the investors. They're going to be in there for a long time, and
yeah, and getting that chemistry is really important, right? Like, you're getting into bed with these people for a long term, and I think certainly with Harrison's experience, really making sure that you had investors that really believed in the vision of the founders and were prepared to give them time to execute on that vision was really important. So it's not just about the money, right, James?
Yeah.
It's also about what, it's an understanding and appreciation of the vision, the founders, and also the value of the business.
That's right. You want to have some value alignment with the investors if you can. I think, I mean, it's hard to ask for that if you don't have any investors, so you just sort of take what's given. But where you do have a choice, I think it's really good for the long-term health of the company to choose investors that believe in your vision, in your mission as well. And we're very, very lucky to have, the investors that we have. So the lead investor for us was Blackbird, and we have Skip Capital, and we have Horizon. So those are our 3 institutional investors. And we know that they believe in our mission and our passion to actually transform healthcare all around the world for people who, are not in as a fortunate position as we are in Australia, where they have, good access to healthcare at an affordable rate. And so, the products that we're trying to make in AI is going to try and alleviate that problem. And what you'll hear from some investors, that they'll say that they have patient capital, and what that means is that they're actually not trying to force you every quarter to show certain numbers and show certain return. That means that some of them are actually willing to wait until you decide to have a liquidity event, which is like an IPO or a sale or something like that. So they're not going to keep on pressuring you for those numbers. They understand that some things just take a long time, and I think for some industries it's quite good. For us, it does take a long time to develop some of these AI products, and so it's really good that we have investors that are patient as well, that don't put this undue pressure necessarily on us to show, perhaps financial returns as well. So the journey so far has been really good with them.
So I guess drawing on your legal expertise, I mean, and I assume that most of the people in this room aren't lawyers. I certainly am not one, and this was actually a really good learning experience for me. There's so many different legal agreements, right? You've got a couple up there: shareholder agreement, subscription agreement. You're dealing with lawyers who, let's put it bluntly, they've got every trick in the book, right? And you have to really show your teeth in some of these situations. But maybe what I could get you to do is just talk through some of those common agreements. I think for many of the founders here, or those that are going through a cap raise, that would be quite helpful, I'm hoping.
Right. So in the term sheet, you'll have it basically pretty much like a table, and we'll have, the company's worth this much, the investor will invest much in it, and they'll get this much percentage ownership of the company, and then all the rights that are attached to those shares that are purchased. And that gets translated into what we call long-form documents. So the long form are these agreements, the shareholders agreement in particular, the subscription agreement and the constitution. So whatever's in your term sheet will get reflected in. It's pretty unusual for it not to be consistent, because when it changes, you basically have a moral sort of high ground. So, well, you guys agreed that in the term sheet, so why are you renegotiating that point in the other agreement? So pretty much it doesn't change, because you can always go back to the term sheet, say it was in the term sheet. But the term sheet is not a legally binding document, so they can overturn it, but then it'll be pretty lousy if it is reversed. So the shareholders agreement is essentially what it says. It's an agreement between all the shareholders. So the investors are shareholders just as the founders are, and anyone else that was maybe in an angel round as well. And it governs how they deal with their shareholdings with respect to each other. So it protects situations where you want to raise more capital. So you've got to give the right of first refusal to the existing shareholders, so that they can top up their amount as well. It also governs things like good leaver and bad leaver, especially for the founders. So what the investor wants is the founder to stay for a certain amount of time, because you can imagine the situation where the investor invests a few million and the founders the next week said, that's great, I'm going, right? And then they just walk off, and they've probably spent some money on something that was totally unrelated. So it's there to protect the investor's investment. And so in the shareholders agreement, everything is negotiable, that wasn't already agreed upon in the term sheet. So what I'd say is to, always still think about the best position for the company, for the founders. Just because they might be preparing the shareholders agreement, their lawyers are, doesn't mean that it's set in stone. So they might say things like, well, this is our standard agreement. The reality is there's no such thing as standard. And it shouldn't even matter that this was the most recent thing they did on a previous deal, because every deal is unique. And so I think if you can try and step back and working with your own lawyer, try to think about, well, how's this thing going to unfold for me from a risk point of view? Can I agree to these terms? Can I live with these terms? And if the answer is no and it's unreasonable, then you really should sort of push back and negotiate for something else. And so it's that kind of conversation. For us, I think, it generally takes about a month or so just to deal with those long form agreements. And that's really at a fast pace that needs to be done. The subscription agreement is a much more easier document. It just basically lists out all the investors and how much money they're investing and how many shares they're going to get. So that's more straightforward. And the Constitution is even more easier. The only thing in the Constitution will be things like voting rights. So you might want to negotiate whether your founders have what I call super voting rights for certain things. And the reason why you might want to think about that is if you think about like Mark Zuckerberg at Facebook, he's got super voting rights. So he's got a class of shares, so each time he votes, it's worth 10 votes of everyone else. And he only needs, how many does he need? 10%, and he can carry any vote at that level. So it means that his equity interest doesn't have to equal the same voting interest as well. So he can still sell down his equity interest, but he still controls, which means that he can't get fired, for example, right? And that's important because, and the way you'd argue it to investors perhaps would be to say that, I have a very long-term vision, and if you guys are measuring me quarter to quarter, then I'm going to have some lumpy quarters. And so it's not really fair that, you fire me as the CEO or whatever. So you want to have at least some stability that says that, for certain things, I can be terminated, but for other things, I don't want to be on a hair trigger that way. I don't want to feel that pressure because some things take a long time to actually develop.
Yeah, and I think we've all been familiar with those horrible nightmare scenarios where you've got a founder that's been ousted, right? So this sort of stuff matters, right? So, the worst case for those of you that have got your own businesses is to get voted out by your investors. So this is really a protection mechanism for you. I might just do a straw poll before we start sort of asking more of the investor type questions. Has anyone got a question at this point in time that they want to raise? Go for it, David.
You talked about institutional investors and that they should be they really have to be aligned with the vision of the company or the vision of the founders. I can see that happening in an angel investor, but if it's institutional investors, they're a group of investors. So how do you approach that such that like everyone is on board?
Yeah, I think for the institutional investors, so these are the investors that continually repeat and invest into multiple startups because they have their own fund, and they usually get their money from superannuation or other funds, that say, I want a return or I want exposure to the startup sector, for example. Those funds will usually, on their website or other material, will say, this is what we are passionate about, this is what we're interested in. So they'll say, we care about the environment and about zero carbon things, or we care about, this kind of social cause a bit more, or we care about healthcare, for example. And so sometimes you get hints already from the kind of investors and they sort of communicate what they want. The ones that don't, that just requires a kind of conversation to sort of tease that out of them away, in a way. So you can pitch to them and you can sort of sense by their reaction, do they share? Because sometimes they actually will voluntarily share, I've invested in XYZ and they're also in that area, and they talk really passionately about it, like they want to make a change, or they actually might share a personal story. So you can pick up those kinds of hints. Where perhaps if you find an investor that's quite dispassionate about it and just focuses on your balance sheet page, then maybe then really what they're there for, which is fine. I mean, at the end of the day, they're there to earn investment. I mean, you can't be too choosy if there's not a lot of options available. But where there is, maybe there's a better alignment on that. The other thing to align on is also what other sort of benefits you have by having that investor on board. So if you're looking for a global sort of expansion, it might help to have an investor from overseas in a market that you want to go into that's got a really strong network in terms of the sales and distribution channel. That might be really helpful as well. And also sometimes some really big funds, they just carry a lot of I'd say a lot of publicity behind it. So imagine if you have SoftBank as an investor, I mean, you'd be on the front page and people will know you at that point in time, so you get that publicity thing, which helps in another way in terms of recruitment. So when we were small, like, no one knew about us at all. Like that was my question. I was like, who are you guys, right? And so, but once you get some investments behind you, they sort of rub off on you. And so if you're smart about it, you can do a bit of a public relations type of campaign, contact a journalist and things like that to try and help get your profile up. And then the next time when you put out your job ads and you're hiring full stack engineers and things like that, they're not asking who are you, are you solvent, all these kinds of questions, right? Because I'm sure when they go to Facebook they don't go, oh, you have a runway of 3 years, right? So it really helps, and so that means that you can attract the stuff, which is the whole point of actually raising capital in the first place. So the whole thing sort of works upon itself. Yeah.
So what about the taxation part? Because we have to also provision that when we are raising some funds.
Yeah.
Number one. Number two, what should be the structure of the company? Should be listed in Australia or US or Bermuda Islands to optimize our tax planning?
Okay. I'm not really a tax expert, but what I know is from my experience is that we're quite lucky in terms of one of Malcolm Turnbull's presents to us was the startup tax concession. So you can implement an employee share option plan, and the tax treatment of that's very favourable. Tax is only payable on disposal of the shares. That's the capital gains event. So when you get the options, they're granted to you and they vest. That's not a CGT event. You don't have to pay tax. So the employee can hold those vested options and they can convert into shares, and that's fine. And then when they sell the shares, then it's based off that price that at when it was exercised. So that's the one way to attract people to a startup, because it's kind of hard to bring people to startup, because if they've been working at, I don't know, like the CBA or really like solid steady employer, and you ask them, well, come take a risk on us, but things might not go well. You need to sort of reward that, incentivize them, and so one way to do that as both a retention mechanism and a performance kind of mechanism is to use the ESOPs, the options as well. Sorry, I forgot the second question. There's a tax as well. About listing, yeah, so we haven't, obviously we're too early for that to happen, but I mean, that's a liquidity event. So there's two types of liquidity events. You sell out to, so someone buys you, for example, like Google, it says, I'm going to pay, whatever, and buy you out. The other one is to IPO, so you're selling to the public market, and then you just trade on a stock exchange. From what I understand, the stock exchange question is based on your revenue, so you need a certain revenue to list on certain exchanges in the first place. And one of the considerations is, is my market capitalization big enough for me to be on an index? Because as soon as you get on an index, then all the pension funds or superannuation funds have to buy a portion of your shares to fulfill that index. So you want to get to that level. And I think to be in the S&P 500, you've got to have a market cap of about $7 billion. So that might be the right time, because as soon as you list and you're at that market cap, then you're automatically included in those pension funds things, and then you'll find that you have more liquidity in your stock, and then potentially could go up. But for us, these are questions really far away in terms of listing. Right now, we're trying to use the capital that we raised in an efficient way to grow the business and to develop products as well.
And Mohit, I am from EY and I have got colleagues in tax. So without doing a subtle plug, I'm happy to refer you to some of my colleagues who might be able to help you with some tax structuring. David Gumley is giving you a bit of a wry smile. Always be closing, as they say. I think what I'm also really curious as well, James, about is I think David sort of touched on this as well. Investor dynamics and you know, everyone's got their own agenda here, right? So I think if we reflect back on the Harrison.Ai journey, we had Blackbird Ventures being the lead investor. You had Skip Capital. So for those of you who don't know who Skip are, think of Scott Farquhar and Kim Jackson. So they've got obviously a big passion for health tech and AI. And then you had, you know, Horizon Ventures. So this is Li Kai-shing's investment arm. And then you also had Ramsay Healthcare chucking in some money. So you've got sort of different investor profiles. You've got to get Blackbird happy first, and you've got to get all these others. How did you manage all of that? What are the things that you'd want to tell these first-time founders?
So, yeah, when you have multiple investors, then each of them want to have their say, and that's perfectly normal. What you want to do is try not to be pulled apart and be torn apart by everyone's different interests and trying to appease everyone. Because if you try to do that, you really end up with not a lot. So the way, you know, one technique is to, instead of doing everything simultaneously and try to close that round really quickly, you switch it to a sequential kind of approach. So it's pretty reasonable to say, look, I'm going to negotiate with the lead investor first, and when I'm done with that, I'm going to go to the next one and the next one like that. And when you go to the next one, you say, you can say that, well, I've done a lot of negotiation with the lead investor, and I'm pretty sure most of the main concerns are already addressed. And you can say this, whether it's going to be accepted or not is another matter, but you can say, look, I'm not going to entertain any further trivial amendments to it, right? And you're saying that to the investors' lawyers, but obviously the investors' lawyers, they act for the investors, so they just don't really pay attention to it, and they introduce stuff anyway. And then you say, yeah, but I said not to introduce trivial, and they say, yeah, but that's not. And I said, but is that really essential? And then, so you have this to and forth. But then at the end of the day, you're not solving the problem. You need to get them over the line in terms of being in a position to sign it. So you have to really work the problem, I find. So you need to really be in a problem-solving mode, and so they're going to come back with their changes, and you're going to think, you know, can I live with that thing? Is that really acceptable? Are they asking for too much? Are they asking me to promise things that I actually can't promise? So they might ask you things where, through no fault of your own, you could be in default of that. So, and I would say to those things, if I can't control it, then how can I give you an undertaking or a promise that that's going to happen? It shouldn't happen, because that means on day one I could be in default. And you can just basically say that to them, and they should understand the logic behind it, because sometimes they just try to take a bit more, which is what you expect from their lawyer, right? That's what they're getting paid for, is to act in the best interest of their client. They're not trying to act in your best interest, and your lawyer is trying to act in your best interest. So we had a lawyer assisting me as well, and so we try to look at it from different angles. And you definitely want someone, when you're choosing a lawyer to help you with the capital raising, which you'd be crazy not to have a lawyer to help you with it, but someone who's had a lot of experience with capital raising, acting for the actual founders, because you want someone that has repeat kind of experience, and especially dealing with investors, so that they know, you know, all the different ways that they can be sort of negotiated against. And so you get that wisdom from engaging that kind of lawyer. I think it's a little bit dangerous probably to use a lawyer that probably this is their first deal, and if it's a big round or something, or even if it's not a big round, if it's a small round, because what happens is it'll come and bite you later on, because you've probably given up too much equity, and you're probably giving away too many rights as well. And so when you go to the next round, it becomes really difficult. And then you're like, oh, well, that's because I did whatever in the first round or something like that. So it is worth, you get what you pay for kind of thing, but definitely do your due diligence on whichever lawyer you engage.
Where do you find them?
Well, I mean, the acceptable answer to that is you go to the Law Society page and there's a list of lawyers and you call. But the better way is probably through word of mouth, right? So if you're in a space like this, or or you can just probably walk into a WeWork, I reckon, or anywhere, right? Any co-working space, and just be friendly with people and ask them where they are in their journey. And I'm sure some people say, I've used this and I really recommend them. Yeah. So that's usually kind of good. And actually, from that point, you can actually find out some pricing as well, so that when you do approach that lawyer or whatever, and you're canvassing a few of them, you'll roughly know where they sort of sit in terms of their pricing range, and yeah, pay what you can afford, of course, but yeah, having that personal touch is kind of interesting, and actually they might be able to introduce you, so you might be able to bypass a lot of the, checking, are you a legitimate client, all this kind of stuff, because you're sort of like vouched for by that other client. Because as lawyers, one of our concerns is that you have a lot of tire kickers that come in and they're not really ready for capital raise. And so you have to spend 30 minutes or an hour talking to someone who's actually not really ready to, and that's like $500, $600 an hour that he's just spent, talking to a client that's not actually going to materialize into a job, right? So there's risk on both sides as well.
So are you pitching, or as a founder, are you pitching then also to the lawyer, such that the lawyer is also in line with your vision? And if they are in line with your vision, they could probably help you better.
To be quite honest, the lawyers will be in line with whatever you say.
You're paying them at the end of the day.
You're a client, and you're not asking them to do anything illegal, so they're gonna take on the job, and they're gonna say lots of things, right? So just like when you go to perhaps buy any other things, right? So I think you can ask those questions, and maybe if you've got really good senses, you can pick up on that, but I don't think that's important. What you want them to do is actually execute the job really well. You want them to be a seasoned lawyer that is really going to look after your interests, because they've got all that wisdom, and they're really known as a formidable lawyer for founders, and that's going to be really good, because by having someone in that corner of your ring, when you come up against the negotiation rounds, that person's going to come with their profile, right? It's like having Mike Tyson in your corner, right? And the other side's going to be like, oh, okay, so I'm not going to try my usual stuff with them, because they're going to see right through it potentially. So it does help to have some name recognition as well, but also it has to come with actually some substance too.
Could you give them ethos?
No, usually you don't, because it's like a conflict of interest, because as soon as they take an interest in your company, the conflict starts to arise, because do they act in your best interest? Because now they've got an interest, so they might tell you to do something because it protects their position. So cash is usually preferred, I think. Yeah.
Good.
Sorry. So you mentioned briefly the right time to get an investor in. Is there any rule book or anything where you say a gut feeling, we made, let's say, $1 million or whatever, now we have to get some capital in? What is your experience around that?
I think you need to sort of have a quick look at your bank account, and if it's running out, then that's it. Usually you need to go raise some funds. I think, and you need to have a plan where you know how to spend that funds, because investors are going to ask you, like, what are you going to use my money for as well? So if your plans only require 10,000, you say I want to raise $1 million, then they're going to, what am I giving you so much money for, right? So they want to know how it's going to be spent, and they want to know that when it is spent, that they're going to get a certain return at the end of it, and it's a lot of the times the return will be extraordinarily high, right? Because otherwise, why would I sell part of my company, so the risk capital, instead of going to get a loan at 7%, 8% from a bank, right? Because I don't have to give equity away to the bank. I just have to repay the loan. So if I'm going to make money, a quarter of town, it's better for me to do it, because then I still own 100% of the company as well. So you only go you only ask for risk capital where, the bank's not going to lend to you because A, you don't have the revenue to justify, and you don't have any security to get a loan. So it depends, but you can raise for different amounts. But I mean, if you're going to engage a lawyer, then it's got to be over a certain threshold. Otherwise, it's not going to worth engaging them as well. So I'd say anything, probably above 500 to a million. You probably you want to engage a lawyer. Maybe not the best, maybe, but yeah, larger rounds means you should be looking for the best service providers to protect you.
I think we're probably getting close to time. Have we got another few more minutes? A few more? Okay. I mean, I guess one question that I thought I might raise just maybe on behalf of some of these founders is lawyers can employ all sorts of different negotiation tactics, whether they're working for you or, they're the investors' lawyers. I mean, what are some of the gotcha things that, I guess first-time founders or people that are going through this process for the first time need to be aware of?
Yeah, so the other lawyer, they come in all different kinds of personalities as well. Sometimes some of them will be very aggressive and confrontational just to see whether you're going to react, and some of them will just appear to be your friend, but they're not really. And so what they'll do is they'll put forward their client's position, and they'll have certain clauses which say, and you'll feel something's not right about it. It feels kind of lopsided. So what you need to do really at the end of the day is just call out these things and say, look, that clause is unfair because of whatever, and then you just explain it to them. And then you wait to see what they say in response, right? You want to understand where they're coming from, because maybe it's justified. Maybe they've had an experience where it resulted in them having a clause like this, because you don't understand it, because it initially looks just strange. And then what you want to do is you want to talk about it. So you want to be in that kind of problem-solving mindset, because what might happen is you want to find a sort of a situation where you can both agree. It's not necessarily the middle position, but it's a position that you can both agree upon. And so, but you can only understand that by having a conversation. So you say, look, that's not fair, or can you please explain why this clause is like that? Because the way that I understand it, it's like this, and this is why it's kind of bad for me, and I don't think that's fair or it's reasonable. And then that's how you initiate the conversation. And usually you do it clause by clause by clause. And so what you should usually do is just go through the agreement and then just sort of mark or highlight those things. And then when you get on the phone and have a telephone conference with the other side, you just go through it from start to finish. And they might have an answer immediately on the telephone conference, or they'll say they'll just go away with it and sort of have a liaison with the client to discuss it, and then they'll come back and see, whether they counter it or they just explain or something like that. So it is a little bit of a slow process, but this is the only way to get an optimal outcome for both parties. Because the easiest way is to say, that's fine, I agree with all your stuff because I just want the money and see you later. But I think what will happen is that you'll have some regret later on, because some of those terms you're like, oh, I really should have pushed back a little bit on that, and it was really unfavourable in the end of it.
And what were some of those clauses? Like, I mean, maybe not in this instance, but perhaps in other situations that you've been involved in.
Yeah, so general clauses that you want to really have a long, hard look at are good leaver, bad leaver provisions. So good leaver, bad leaver is regarding founders usually. And so what usually happens in a bad leaver situation is that the founders will forfeit their shares because they're a bad leaver. Good leaver usually means like the founder has died. You're a good leaver because you didn't do anything kind of bad. But bad leaver is stuff where the founder leaves and joins a competitor or starts a competing company. You're a bad leaver, so you forfeit. And sometimes bad leaver includes stuff like poor behaviour. So now we're seeing more of this happening, which is a good thing. So founders where they've exhibited poor behaviour like sexual harassment, embezzlement, things like that, illegal activities. So yeah, I mean that's quite right that they should be classified as bad leaver and they should forfeit their shares because a new leader is required in that organisation, and that founder shouldn't be allowed to keep it. Right? So you agree to those things, but what you want to be a little bit certain of, like if you can agree in principle of those things, then you want to think about, so by whose standard is your behavior poor, right? Because sometimes the investors want just a low threshold. They just want a strict thing, and like if you go below that, you're out, right? But sometimes some things are hard to prove. Like I don't think necessarily it's fair that someone loses a whole ton of their shares, their life's work, just because there's an allegation that's made in the company by somebody, or somebody new, for example. You don't know if that somebody new has been sent in by someone else because there's a lot of money at stake, so you don't know what people are up to. So you might say, okay, an allegation of poor behaviour may not be sufficient, so I need to have an external third party validate it. And so you might say, oh, I want a conviction, right, for that. And the other side might say, well, that's ridiculous because, going through the criminal justice system takes a long time. And then you go, okay, that's fine, I agree on that. Then it's like, well, then try to find a middle ground. So how do you find an external arbitrator that can listen to the facts, and you'll be comfortable that that was an impartial sort of judgment? And then that's something that both parties could agree on as well. So there are things like that you need to be a bit mindful of, which can affect the rights of your founders and sometimes even your employees, because you want to check as well the employee share option plan as well to make sure, because they also have good leaver, bad leaver provisions as well. So there's just these things that you definitely should look a little bit more at, and also look at the special resolutions that are reserved for the that require the institutional investors to also vote on as well, because those are the ones that you need to convince either all the investors or the majority of the investors along with the founders to pass. And you don't want that list to be really long, because that's going to slow things down. You want it to be quite small, and that's just going to make it easier to make decisions as a company. So you want to just leave only potentially the bare essentials. But all of these things depend on the relative bargaining power that you have with respect to the investors, because the situation can happen where it's like they just say, look, we're not going to agree to that. And then so you have a decision whether to continue having that investor come on board, or saying no and then going out there and trying to find another investor to take up their share as well. So that's a decision that you have to potentially make.
Is that in the shareholders' agreement?
Yeah, so the constitution would cover the voting at board meetings, the directors' votes. The shareholders' agreement is just mostly regarding the rights of the shareholders with respect to each other. So, if I'm a investor, I can't just sell it to anyone else, and then there's a brand new investor that no one likes, for example. So the offer must be to the existing shareholders so that they can soak that up, right? For example, right? Because you want to have some control. Because if you didn't have a shareholders agreement, then I could just sell it to a competitor. They have a blocking stake in your company. Then it's pretty miserable after that. So those are the main things I'd say to negotiate, and those clauses you should pay more attention to. So if you have a good lawyer, they'll just tell you which ones you should definitely have a better look at. If they don't highlight that, then I'd be a bit concerned. Yeah, maybe. But this was my first capital raise, actually, to be honest. So before I mainly dealt with IP issues. So I'm a patent attorney by trade, and so I do patents, trademarks, and confidential information, things like that, and some commercial agreements as well. So I actually hadn't done a joint venture before, and I hadn't done a capital raise before until I came to Harrison. But then, when I got there, I was knee deep in it. And the thing is, there's no university course that's capital raising 101, right? You can't. There's corporate law, which I studied as well. These are all core subjects, but it doesn't teach you going through a capital raise. They teach you things like litigation stuff generally, but not to this specific level. It's not like here's a subject to teach you how to enter in a joint venture and with an AI company and a medical scanning company. There's not to that specific, but you have some basic principles that you learn in your law degree, and then you try and apply it to the fact situation that you have. And essentially it's just reading. You read and you understand what the words. You got to understand it to a level that you feel comfortable in understanding what it means. And if you don't understand it, then I think you know, what you do is you just ask the other side, you know, what do you think this means? And they'll tell you, and then you'll say, oh, okay, that's not exactly what is written there. So let's just amend it to be exactly what you said or something like that. So I think always feel like you can have a conversation with the other party. It is a conversation, and even though you're sort of like on opposite sides initially, eventually they're going to be on the same team as you. So you got to be very conscious of that. And same for both the joint venture and for capital raising, because the investors will be with you as well, and the joint venture partner will be with you as long as the joint venture is there. So you can't go too hard, because it will leave a bad taste in the other person's mouth, and then it makes it very difficult to work and, you know, work together to accomplish a common goal. So I think it's very similar to like the Democratic nominee part, right? So they all fighting, but they're actually all on the same team. But you want to pick a leader, and then once if it's Joe Biden, then everyone just rallies behind him. But if you fought really bitterly, then it's hard, because you got a faction over there that's just like, that was really lousy, and I can't, you know, it sort of still stings. So you have to be a little bit conscious of things outside of the legal dynamic as well, and think about the relationship too. Because if you ground it in things in things that are reasonable and fairness, and you make your point quite clearly, then people are more likely to agree. But if you just like, I just want all the value, and then you have nothing, like a zero-sum game, then I think you're going to find it's going to be very difficult to get an agreement, if at all, if that's your mindset.
It's very good advice there. I think we're probably going to be one more question maybe from the floor. David?
James, I'm just curious, sort of going back to the beginning of the journey pre the IMED JV, given that sort of supercharged the discussions with the investors, had there been any investment offer prior to the JV with IMED?
Yeah, there'd been interest. There'd been interest from other investors earlier on. I can't get into too much specifics, but as soon as, you know, because they had actually success in terms of the embryo selection AI tool, and there was a little bit of publicity around that, and Harrison was mentioning that, I think there was some interest at that point in time. But I think, you know, in the wisdom of the founders, they knew that they were going to move on to something bigger, right? So the radiology market is 10 to 15 times bigger than the fertility market. I mean, that for obvious reasons, right? Because, you know, most people are fertile, right? But in radiology, you know, people have all manners of disease, so, you know, you're more likely to require it. And so they made that good decision, like, why raise just on that business when we've got something bigger coming on? So therefore your valuation would go up as well, so if you just wait it out a little bit longer.
So had there been some feedback around seeking a JV to supercharge?
So in terms of the corporate structure to engage with IMED, I mean, that's something that the founders really had thought about, right? That's a key decision, right? Because if you don't choose a JV, what's the other structure, right? You're just a technology supplier, and that's really at the low end of the scale. Because once you do the job, you're not exposed to the upside, right? That you've created for them. You've created value, and you've only just taken a fee for service kind of thing. So I think, you know, having a JV in this particular context has been quite a good optimal structure for both parties as well. I think, you know, from the other party's point of view, they know that we're in it for the long haul. So we don't just roll out something that's so flaky, and yeah, we might have, you know, you might give some warranties and stuff like that, but at least we're going to be around for the long haul. And remember, the thing with AI is that it gets better over time. So you want to be there to keep pushing it in the future, to the next version, the next version, the next version, because AI gets better the more data that you give it to train. And so having that data supplied from IMED and to build AI better enables the JV to dominate that market, because AI is a winner-takes-all market, just like in a lot of other, like social media, for example. There's only Facebook. Who's the next one? I don't know. Same with eBay, right? There's just one, and then there's some other small guy just surviving, right? And AI is the same thing, and it's AI in specific fields, I think. So how do we ramp up to that level to be dominant is pretty key. So for us, speed is a really important thing, and yeah.
Thank you.
conscious there haven't been any questions on this side of the room, so just thought before we close out, if there were any. No? Okay. One more, okay.
What should the structure like? And first question is that after how many pitches you got success?
So I wasn't there when they were pitching. I was there when they pitched once. And so I didn't know what it was like before. But from what I understand is, just like with everything, the more practice you do, the better it is. When I was there and they pitched and I was in the room because I had to talk about IP, it was really good. Like, it was the best pitch I'd ever seen. It was so polished, but you don't know that there was 100 iterations before then. And actually, I could see on our system an early pitch deck, and it wasn't super polished. But by the time it got to that part, which was right when we were about to do that, it was really, really polished. So the points were exactly what you want to communicate. And so what you want is a situation where all the top questions that the investor wants to ask are already covered, like in the slide deck. So basically, the investor has to just talk about very minute things. So the main thing the investors always want to know is, do you have product market fit? Why now? Why, what's so good about your team? All this kind of stuff, right? And if you answer all those things, you're giving the investor confidence. So then they can just drill down into other things which are just usually kind of unique to each investor, but all the main headline stuff is in there. And you definitely need a financial slide. You definitely need an IP slide, which is what I usually come here to talk at Haymarket HQ about, the importance of IP. A lot of startups don't understand the value of IP, because without IP, what is unique about you? So from the week after you launch, why aren't you simply copied, right? And so what's your, we call it the competitive mode that distinguishes you from other people, because the investor wants to protect their investment. So how do you protect it? You say, I've got a great team, but your team can come and go. Your IP always stays with the company, and so you want to lock down anything that's proprietary. If you're selling online like clothes, then your brand is the most important thing. For us, as AI, it's a combination, the data and the patented processes that we have. Brand to some extent, but not so much, because we're providing you a solution, right? So it depends on the nature of your business. But if you overlook the IP, and usually the investor will go, so what about IP? And your answer shouldn't be, what's that, right? So you should be like, you should say, I've really thought about it, and this is my plan. And you just do it on one slide, and they'll be really happy.
Thank you very much.
Joey, so I just want to know what's the relationship between the investor with Harrison.Ai and Joey and IMA?
Right. So the relationship is so the investors have invested in Harrison, so they have a certain shares in Harrison. The JV is a commercial relationship between Harrison and IMED. So this is all public, so I can tell you. And so IMED and Harrison, we form a joint venture company, a separate company. We call it Allocate.ai, and so we own different shareholdings of that joint venture company. So in a joint venture, what happens is the two parties, or however many parties, they contribute to that. So they usually contribute money to capitalize the company because it needs money to spend. And for us, Harrison, we contribute IP. So our knowledge, because we have AI engineers and all the expertise. IMED doesn't have that. What does IMED have? IMED has the data, right? And IMED have the skilled medical practitioners, the radiologists. And so they also contribute that expertise. And so with all of our pooled resources together, it means that Annalise has a good chance of being successful, and that's why we formed that joint venture.
Great question. So I think we'll probably close this session. I think there's going to be some networking drinks afterwards, so you're more than welcome to have a chat to James. But before we wrap, James, any final thoughts, anything that you would love to impart with this audience, any pearls of wisdom, anything you just want to be able to share, reflecting on your experience today, that you might want to share with these founders?
Yeah, I think just, when you're going through a capital raise, I mean, it's a really stressful time and there's a lot of things on, but be prepared for a long journey. So be, pretty patient with it. There's going to be a lot of reading to do, and always go in thinking that you can negotiate on anything really, and, think about what's best and fair for you, and go back to them, because the other side, they generally should be reasonable and looking for a mutually acceptable outcome. And so just don't simply accept what they have. And I think that's the main thing. Don't just rush in. I know for most people it'll be their first time doing a capital raise, and so this is something that we can impart, is that you can, negotiate things and get things that you're very comfortable in. But after you get it, it's definitely a good thing, because then it's one less problem and you can focus on actually delivering on whatever the mission is that you have set out to do, which is a really fantastic thing to do, because that's the whole reason why you guys are starting startups in the first place, is to obviously change the status quo and do something different.
Cool. All right, well, thanks so much for your time, James. If I could just turn to the audience and just join me in thanking James for sharing his time. And also a huge thanks to Haymarket HQ and Lauren Montino and Duke of Van Bremen for all the stuff that you do. Thanks so much for hosting us. It's been great to have you. So sit back, just stay back for some drinks afterwards, and we'll go from there. Thank you.
Thanks, Melinda.